So, purchase contract. We'll get through it then. We're going to talk about what are requirements to form a binding contract. How many of you have had basic business law class? Okay. So, a contract, whether it's a real estate contract or a contract for purchasing goods or services, is something you'll see in business law. Real estate law piggybacks, except the primary purpose of our contract is the real estate transaction. We're going to talk about offers and acceptances. We'll talk about common terms in real estate agreements, again, what we reviewed. How contracts are interpreted. This is where we're talking about when something's written initial versus typed in versus addendum. We'll explain the importance of the statute of frauds. Understand defenses to the enforcement of a contract, and also describe remedies to enforce the contract. So contract formation. This is any contract. Elements are required for parties to create a valid real estate contract. You have to have an agreement. So an agreement is offer and acceptance. What are we offering? What are we offering when we're selling real estate? The house, the lot, whatever it is that's the real estate. And so the offer is to make an offer to buy that piece of real estate. The acceptance is the counter, is the signature, the acceptance back. It's two parties, the meeting of the minds. Consideration. What is consideration? When we talk about consideration. Money.
What's being exchanged.
And it doesn't always have to be money. For the most part, it is money, but consideration can be services. I can rent a house to a handyman if he agrees to do a certain amount of improvements to basically pay his rent. So it doesn't always, it can be services. It can be goods. We can exchange, like-kind exchange. Real estate for real estate. And no money's involved. We can actually do real estate for real estate. So consideration is typically the money or the financial aspect. What are we giving for it? Capacity of the parties. When I talk about capacity of the parties, what comes to mind? Capacity.
Maximum, holdings.
Okay. The financial capacity. How good, how grounded are they? What do they bring to the table in terms
of... lucid.
Yeah. So their financial capacity, what do they bring to the table? Lucid, meaning?
Solid mind.
Solid mind. So capacity, they cannot be, my mother-in-law is 91 and she's doing very well, and she can tell you to the penny what her bank account is. She doesn't hear very well sometimes. She has her good and bad days. We call that selective hearing. But she understands totally what's going on in this world. She still goes to water aerobics. She still drives herself around and stuff like that. So she's doing really well, but she has capacity. Now, if she signs a contract and goes forward with it, but one of her heirs or beneficiaries disputes what she's done, one of the first things they would claim with a person that's old is what? Mental capacity, senility. Are they senile? Was she senile? Did she really understand what she was doing? And now I'm going to tell you, none of my in-laws are going to do that. None of my brother and sister-in-laws are going to do that because they know she does sound like. But that's the mental capacity. The other thing we talk about is, are they minors? Are they legal of age to sign contracts? If a minor can enter into a real estate contract, a minor can enter into it. But when the minor reaches majority, so that 16-year-old reaches 18, they can come back and say, I'm sorry, I didn't know what I was doing. They can claw back, or they can basically say, it's not a valid contract. So if we wanted to work with minors, in college dorms and college towns and rental apartments, what do they typically do when they're dealing with college students? Cosign. And who do they have cosign? The parents. Because the parents have money, the parents are legal age. And that way, so we can deal with minors, but the thing we want to do is have the person who's responsible for them also sign the contract. So then it becomes a binding contract. Capacity we talked about is what do they have? What do they bring in? Legal purpose. You got to have for a valid legal purpose. We can't be zoning. You can't put, a factory in the middle of a residential area. Hey, I got a good deal on this land, but I'm going to tear it up. I'm going to build a factory here, but there's houses all around it. So zoning would say that's not a legal purpose, so therefore we couldn't enter the contract. There's all kinds of things that go on in zoning today about how you can and can't use property. I remember years ago we were dealing with a cell tower. Now we look out the windows here and you can see cell towers and towers all over the place. But the first cell tower user that came to the Planning Commission, when I was on the Planning Commission, we didn't have a way of saying no because we didn't have rules about cell towers. So they put this ugly cell tower right on the main drag, and the owner was getting $2,500 a month for it. It was a good little deal to do it. But we couldn't say no to it. And he brought a good attorney with him and said, Village of Fairfax, you all don't have rules about cell towers. So we're going to put it right here because basically it's allowed in the commercial zone. So we had to allow it. But what did we do right after that? We rewrote the zoning code. And we said, okay, only cell towers are allowed here or here. Okay, so we have zoning and a legal purpose. You know, if it's a crack house or something like that, obviously it's not legal, so it's not going to be allowed. We're not going to let it happen. Satisfaction of statute of frauds, writing or evidence of record. In Ohio, to be legal, if you're dealing in real estate, it has to be in writing. Now, if you're doing a lease and it's less than a year, it doesn't have to be in writing. It can be a verbal lease. But if it's a year or longer, or if you're purchasing real estate, it has to be in writing. So that's statute of frauds. The offer. We have an offerer, person that makes the offer. We have the offeree, the person that receives the offer. Typically, the offeror, the person that makes the offer, is the person that's going to create the contract. If they want to buy it, they're going to create the contract. Today, you can go online, anybody can go online and get a contract. To go online and get this contract, though, that I'm giving you, you got to be a member of the Board of Realtors. I'm not a member. I have somebody give this to me because I wanted to share with you what is typical in our market. And so typically the person making the offer writes the contract. Unless you have a real estate agent involved, the real estate agent, typically that's part of what they do. They're going to bring contracts. They're going to bring forms with them. That's part of their toolbox. They want to help you make the contract, the deal happen. The offer has 3 elements. It has to be an objective intent to be bound by the offer. Terms of the offer have to be expressed definitively and with reasonable certainty. So when we go through this contract, it says this is that piece of property we're buying. This is the amount of money we're going to pay for it, and we're going to close by this certain time. Those are the some elements that make it a valid contract. And the offer must be communicated to the other party. In other words, if I make the offer, I'm going to give it to them. There has to be acceptance. Contract. We have termination of offers. Most commonly, means by which an offer could be terminated include lapse of time. Time is of the essence. How many of you have heard that phrase? Time is of the essence. We like to say, in real estate world, time is of the essence. And before we had fax machines, before we had email and things like that, time is of the essence. We used to give people 48 hours. Why so much time? Because it literally took that much time to drive the contract across town or give it to somebody to sign it or do it. A day or two was common. Today, we can give people an hour. Practically speaking, we can get it to them. Typically, it's 24 hours. So we typically give them a day. We also have this thing called rescission, where if you're buying a piece of real estate or you're buying something of value, any buyer can come back 3 days later and rescind the contract. So that's an Ohio rule that says if you're buying a car or buying a house or buying something like that, you have 3 days to rescind it. So we still have that 3-day period. But okay, so we have counteroffers. So once the offer is made and you're offering and the seller's counteroffer, they basically create a new contract. They're working off the same contract, but once they counteroffered, it's still open again. Everything has to be accepted back and forth. The offer can be rejected. We can give the offer to the sellers and they can just say, hell no, I'm not signing it. That's a rejection. They can revoke it. That's the person making the offer can say, oh, sorry, change your mind. I'm pulling it back. Before you all had a chance to accept it, I'm pulling it back. I'm revoking my offer. Death or incompetency of either the offeror or the offeree terminates the offer. So, I'm trying to buy a house and I die. Obviously, I can't go through with the contract. But I'm trying to buy a house and the seller dies. The seller can go through with the contract. The seller's estate can take over the contract. Destruction of the subject matter. Okay, we've had floods recently down in North Carolina, South Carolina. The house is flooded now. The house isn't gone, but it's flooded. Are you still really going to want to buy that place? There's a lot of things that have to be resolved before we even think about trying to buy one of these places now. Tornado, fire, all those things can happen to destroy the real estate. Now, the piece of real estate, the ground, we used to always say ground can't be destroyed. I figured out a way ground can be destroyed. Sinkholes. But guess what? We have engineering today. We can fill a sinkhole in. We can bring the property back. As long as it's compaction and everything's done right, the property still didn't disappear. It just may not be suitable to do what we want to do with it anymore. Option contracts, we can have basically an option period arises if the seller promises not to revoke the offer. An option with consideration creates a contract to keep the offer open. So think about Rookwood. How many of you are familiar with Rookwood over in Norwood, the shopping center over there? Okay, phase 3, they basically bought 75 houses. There was the options to do that. It took them a while to get the approval. Little do we know they go through eminent domain and all the other stuff. But to buy multiple parcels like that, it takes time. So he issued options. He would pay people $10,000 or $5,000 to basically say, I want an option to buy your house for the next year. You can't sell it to anybody else, but I'm going to give you cash right now. So you basically reserve it for me to buy, and I can act on this contract anytime. That's an option. And that's very common with speculative or when we're trying to accumulate properties to be options. And then the option, again, with consideration creates a contract to keep the offer open. So there's to keep it open for a period of time. Acceptance is when the manifestation, the offer's approval of the terms of the offer. The mirror image rule. However the contract was delivered is how the contract gets returned. So we have this thing called dot loop today. If you guys haven't had a chance to play and look and see what dot loop is everything's online. Contract signature, everything's online, makes it really easy. Not all realtors use it. It'll never be used in commercial real estate because attorneys don't want to put all that stuff out there. They want to be part of it. But this dot loop says you can just initial contract, send them back and forth through dot loop. That's offer acceptance, that's the mirror image. As long as it's all done through dot loop, that's mirror image. But the day I pick up one of these contracts and I fax it to somebody, mirror image says I need to fax it back to them. If I mail it to them or I hand deliver it, mirror image says I'm going to mail it or hand deliver it back. So that's what the mirror image rule is trying to say. However it was delivered to you, you try to get it back to people. The offer must communicate the acceptance of the offer, so there has to be a full round of communication to say, we got it, it's going. Consideration, the bargain for exchange given by both parties in the transaction. We also can have illusory promise, is a promise in which one or both parties can elect not to perform. So an illusory promise is not consideration. But again, it's for performance. Like I said, somebody does services or something to get that, something done. Capacity, we talked about certain classes, the minors, persons under a conservatorship or guardianship. So that person under the conservatorship or guardianship, they want to enter a contract. You can deal with them, negotiate with them, but make sure their conservator or their guardian is also signed. Then it's valid. Persons declared by a court to be legally incompetent or intoxicated. Oh, there was one I forgot. Intoxicated. People like to do all kinds of things when they're drunk and shouldn't be done. Or high or stoned, same kind of thing. The legal purpose, contracts that violate the law are not enforceable. And again, statute of frauds, they got to be in writing. Some note or memorandum has to be in writing to be enforceable. Okay, the terms. We have to identify the parties. Who are the people trying to buy and sell this piece of real estate? A property description. It's not the full legal description. That's a page, 2 pages. It can be a street address, or it can be a unit number for a condominium or something. Terms and conditions of transaction. Is there earnest money? What are the contingencies? We talked about all the contingencies that you can have, financing, inspection, things like that. And then the inspection reports. And then obviously signature of the parties. If you're married, okay, my boss, she just bought a house down in Texas. She's financing it, she's doing it all by herself. But she's married. Her husband's selling the house in Chicago. The mortgage company said, we get it, and this is Sylvia's third marriage, by the way. So she doesn't need him to do anything. But the mortgage company said, we don't care. Even though he's not part of the contract, he has to sign everything because of dower rights. Because they're married, there's rights there. So we asked for signature of parties, and everybody that is married, they all have to sign. Electronic signatures, again, we're allowing to do all this. Risk of loss. Determines which party after the contract has been entered into bears the risk for the property that is damaged or destroyed. Who's going to get the benefit of the insurance proceeds if the property is damaged or destroyed? And there's contract provisions in these purchase contracts. Who's going to do all that? Most of us, when we buy a house, we assume we're going to take over the insurance the day we buy it. And we have to bring usually proof of insurance when we go to our closing. It says we've already got it done. But what happens that 1 or 2 weeks while we're waiting to buy the house? We've done a contract, we've done everything, all of a sudden the house is destroyed. Who gets it? Who gets the insurance proceeds? Who's going to make it good? That's all part of the contract. It's stipulated. It doesn't have to be any one set party. It's what you guys agree on. Plain meaning of the contract governs an interpretation. When interpreting a contract, courts have certain rules with which they interpret a contract. Okay, whoever writes the contract, your attorney, or I'm using one of these standard contracts, but there's something in here that's not clear. The courts will rule against the person that drafted the contract. If there's ambiguities, they rule against the person that drafts the contract. That's why we like this contract too, because this contract's been around. There's not too many ambiguities about it. Parole evidence rule. Prohibits admission of evidence of any prior contemporaneous oral or written agreements to contradict or modify the terms of the final contract. So we've been talking, we've done everything. We might have signed paperwork. We might have had verbal agreements. We might have done everything. But when we finally put it in writing, it's a little bit different. Parole evidence rule says we don't care what you did prior. The final contract is what's going to govern how this is going to be ruled. Performing on contract means carrying out the purposes of the parties intended. So parties fully perform or they'll be discharged. Novation says we can substitute a new agreement or party. We can actually bring another party in to make the contract happen. Okay, and this may happen where we have relatives that come in. Or, when I worked for McDonald's, guess what? As McDonald's, we didn't tell people we were out trying to buy their property. They got huge dollar signs. It wasn't realistic. So we would have somebody else go in and buy it, and then we could come in at the closing and actually it would be assigned over to us. That would be a kind of novation. It didn't matter. The property was still bought and sold. We just didn't want to disclose who we were because we didn't want the price to go out of this world. McDonald's can't compete with Walgreens for a corner location. Sorry, it just is not going to happen. When you make 2 cents off every burger you sell compared to dollars off of prescriptions, McDonald's will never win that one. Remedies for breach of contract. The breach occurs when a contract is not fully performed. So we have something called a material breach. Occurs where the breaching party fails to substantially perform pursuant to the terms of the contract. We have a minor breach. Occurs when substantial performance has already occurred and the breaching party's performance deviates only slightly from the contract. So, again, how is the court going to rule? What are they going to make people do to get to the final to make it happen? A material breach, they flat out didn't do a major component. Didn't get your financing. You didn't have the house, something wasn't ready. You didn't move out. You didn't offer possession. That's material breach. Minor breach, okay, I'm sorry, I removed a piece of property I shouldn't have removed. Or I did something minor that I shouldn't have done. Very different things. Specific performance. So this is what a court can do. They can compel the party to perform to the terms of the contract. We can take them to court. We can make them perform. We can do liquidated damages. Parties agree at the time of the contract's formation what the damages will be in the evidence of breach. Okay, so we have something called earnest money. So earnest money in our real estate world is the money that we put down. It's kind of like a security deposit to make the contract happen. As a buyer, we give earnest money to say, we're so good, we're going to make sure, we're even going to give you earnest money to say we're so good. And by the way, if we don't perform, and it's our fault, the earnest money is the liquidated damages. That's what earnest money is meant to be. But if it's bad, material default, the liquidated damages can be even higher, depending on how we go to court. But this Board of Realtors contract, it's very specific and says that earnest money will be used. And everybody has to agree to that. That is the liquidated damages. Rescission is an action to cancel a contract. Rescission is followed by restitution, which places the parties back in their original positions. This, the contract has never been performed. We want to get everybody back to their original place. Misrepresentation and fraud arises from the intentional false misrepresentation, or a realtor knew something was bad about the property and they didn't disclose. So it can be non-disclosure, it can be silence. Those can all be misrepresentation or frauds. Duress arises when one party is subject to unlawful pressure to enter into a contract. I'm sorry, but when I see foreclosures and short sales, I'm going to tell you there is somebody that's under duress. They're not doing this voluntarily. They're being forced into it from bad circumstances in their lives. But we recognize short sales and foreclosures in our marketplace. There still is a component of duress there. Undue influence arises from the misuse of fiduciary relationship. Okay, we have raw land sales. We have interstate land sales, Full Disclosure Act. What you need to know about this, the ILSFDA, it protects consumers from fraud, abuse, and the sale of lease of unimproved land sold through interstate commerce. So this is when you were trying to go out of state to buy the vacation house, or you're trying to do something like that. You're from one state, you're going to another state to buy it. We have laws that regulate how that interstate commerce is going to happen so that people aren't taken advantage of. It applies only to sellers or lessors of 100 or more lots or parcels, subdivided land, who sell these lots by using U.S. mail or any other instrument of interstate commerce. So a lot of this is the vacation homes, the kind of things we're trying to do, timeshares, different things like that. Requirements of the Act: developers must file a statement of record with the Bureau of Consumer Financial Protection. And then penalties for violating it is rescission rights. The people that enter in a contract can rescind. And there can be civil and criminal penalties against the people that are trying to sell, because it's fraudulent. What they're trying to do is wrong. Okay, so any questions about a contract? Okay, so we saw the contract last week. We went through it, we looked at it. You have it now. What we just read about here and saw here, this is really all business law, is what this is. It's about how to do a contract. And it pertains to the selling of real estate, but it's how to do a contract.